Good evening, everyone. Buenas noches a todos. We have the absolute pleasure of having with us Kevin, which is one of our top international immigration attorneys. Some of you will recognize Kevin because he's already working with you to help you arrive in the United States. Como les decía, tenemos esta noche a Kevin con nosotros, que es uno de los principales abogados migratorios que nos acompañan en el programa. Algunos de ustedes lo reconocen en persona porque él seguramente es uno de sus abogados. Kevin is going to be the person doing a small presentation for us and then answering many questions that you may have related to immigration. Kevin va a hacer una pequeña presentación y de ahí en adelante va a contestar muchas preguntas migratorias que algunos de ustedes tienen con respecto a los Estados Unidos. I beg you to please write your questions to me, okay? I already started to get a lot of questions, so please write your questions to me. I will make sure that I will pass them along to Kevin, and we will try to get through as many of the questions that we can. I know that a lot of people have a lot of questions, but make sure that you please send me your questions. Yo sé que hay muchas preguntas, ya muchos de ustedes empezaron a escribirme varias de las preguntas. Les ruego por favor que me las escriban, háganmelas llegar, yo las voy compilando y durante la reunión yo se las voy pasando a Kevin, okay? So Kevin, without further ado, and again, thank you very much for being here with us. The presentation is in your hands right now.
Okay, thank you, David. I am going to go ahead and share my screen. Right. Can you see my screen yet?
No, not yet.
Okay.
Now we are.
All right, perfect. Technology.
Technology. We got it.
So thank you for having me. Today, I'm going to talk a little bit about the various different options for U.S. immigration for registered nurses.
Buenas noches a todos. Kevin los saluda y les dice que esta noche va a empezar para mostrarles a ustedes varios de los métodos para que los enfermeros puedan inmigrar de manera permanente a los Estados Unidos.
There are two different ways that someone can come to the United States. First, there's the immigrant visa or green card, and that is for someone who comes to enter the United States permanently. And the second way is a non-immigrant visa, which is for someone that is going to come to the United States temporarily through a temporary visa like a TN visa or an H-1B.
Hay dos rutas para poder venir para emigrar a los Estados Unidos. La primera ruta es llegar como un inmigrante de manera permanente a los Estados Unidos, vamos a escribir esto, y la segunda forma es llegar como no un inmigrante, venir como en la forma básica de una visa de trabajo, como un nacional, una persona de otro país a través de una de las dos visas, TN o H1B, las va a describir en este momento.
So I'm going to talk first about the immigrant visa or green card and go through sort of the general steps for everyone. And then I'll talk briefly about the non-immigrant visa options that are available.
Okay. Vamos a describir primero la ruta de visa de inmigrante.
So the first step of the permanent residence process is for the employer that you would be working with to obtain the prevailing wage determination, which we will take care of from the very beginning of the process.
El primer paso para llegar con una visa de residente permanente es que el empleador obtenga la determinación del Departamento de Trabajo de cuál es el salario prevalente que hay que pagarle a la persona que esté emigrando.
In the second step of the process, your employer is going to file a immigrant petition for you. And during this step, this is going to be where we submit your educational documents, licenses, evidence of NCLEX, CGFNS certification, passports, birth certificates, and similar documentation.
Okay. Una vez que se tiene esa determinación, el segundo paso es que el empleador va a poner una petición para que la persona pueda venir como inmigrante, y para poder hacer esa petición tiene que suministrarle al Departamento de Inmigración varios documentos que incluyen, como algunos de ustedes saben, su licencia de enfermera, haber pasado el examen del NCLEX, su certificación, sea por la CGFNS o por Joseph Ansilni, su pasaporte, su certificado de nacimiento, etcétera, etcétera. Toda esta documentación tiene que ser entregada al Departamento de Migración.
And this step in the process gets a response within 15 days.
Okay. Este paso, normalmente una vez que todos los documentos han sido entregados al Departamento de Migración, obtenemos una respuesta de ellos en 2 semanas, en 15 días, porque pagamos el proceso rápido, el proceso acelerado.
The third step in the process is for us to apply for your green card, and we do that in one of 2 ways. If you are currently in the United States, we can file an adjustment of status for you. And if you are outside of the United States, you will process at a U.S. consulate in your home country.
El tercer paso a seguir es solicitar su tarjeta verde, su green card, su residencia permanente, y esto se puede hacer de 2 maneras. Si usted se encuentra legalmente en los Estados Unidos, se hace a través de un proceso de ajustar su estatus, de cambiarlo a su residencia permanente. La mayoría de ustedes van por el proceso consular y es solicitarlo a través del proceso consular.
Is during this sort of the step 3 where you're either consulate processing or filing adjustment of status, where we would be filing for any of the dependents that you plan to accompany you to the United States.
Y es obviamente, durante el proceso consular que se hace simultáneamente la aplicación para aquellos de ustedes que están interesados a traer a sus dependientes a su núcleo familiar a los Estados Unidos.
And when we file your immigrant petition, you will get a priority date on the date that it is filed. And each month, the Immigration Service will tell us which priority date is current or not.
Y en el momento que sus papeles entran a hacer la solicitud de migración, en ese momento usted queda con su puesto en la línea, su fecha de prioridad, que es el que determina qué tan rápido te sale la visa. Todos los meses nosotros revisamos el boletín de visas para saber qué fecha es la que está corriente para el procesamiento de visas.
We cannot file that adjustment of status or complete the consulate process until your priority date is current.
No se puede completar el proceso migratorio hasta que, o el cambio de estatus, hasta que su fecha consular esté corriente, esté al día.
And as part of the process, once we get to the adjustment of status and consular processing, you will have to complete a health screen and a criminal history and immigration history check.
Durante el ajuste final, obviamente hay algunas partes que usted tiene que pasar. Hay que hacer un examen físico. Van a revisar su historial criminal o su historial judicial y cualquier otra historia migratoria que usted haya tenido con los Estados Unidos, porque esto depende que te den la autorización final para la visa.
And those health screenings, criminal history checks, and immigration history checks are performed on each eligible dependent that you plan to accompany you to the United States.
Y estos mismos requisitos son para cada uno de los dependientes que usted decida a traer con usted a los Estados Unidos de su núcleo familiar. Cada uno recibe un examen clínico, una revisión de la parte judicial y todo lo necesario se hace es a nivel individual, no es un proceso familiar, es un proceso que se hace a nivel de cada individuo.
Some of you have asked in the past about the TN visa, which is a temporary visa. And so I'm going to talk a little bit about that. The TN visa is available for citizens of Canada or Mexico.
Para el segundo grupo, que son los dos grupos de visas no migratorios, el grupo que preguntan con frecuencia son aquellos que tienen la posibilidad de aplicar a una visa de trabajo que se llama la visa TN. Esta visa solamente, por favor escuchen bien, esta visa solamente está disponible para aquellos que son ciudadanos de Canadá o México. Solamente está disponible para estos dos países.
The initial period that a TN visa can be granted is for up to 3 years, but there are no limits on the amount of extensions that you may seek.
El tiempo inicial para estas visas es que se la dan a usted por 3 años, pero en el principio no hay restricciones en poderla renovar un número limitado de veces.
Canadian citizens can go straight to the border and apply, and Mexican citizens can make an appointment at a U.S. consulate and apply right at the consulate.
Los ciudadanos canadienses pueden hacer la aplicación directamente en la frontera. Los ciudadanos mexicanos hacen esta aplicación a través de los consulados en México.
And the second type of non-immigrant visa, the temporary visa, is the H-1B visa. And generally, the USCIS does not allow registered nurses to qualify for the H-1B visa unless they are in a specialized nursing role, one that requires advanced clinical experience or advanced certifications.
El segundo tipo de visas temporales de trabajo que hay se llaman las visas H-1B. Desafortunadamente, la gran mayoría de los enfermeros registrados no califican para estas visas, porque estas visas tienen dentro de la asignación un requerimiento de tener una carrera de pregrado y la definición es más amplia porque técnicos y carreras de pregrado están incluidas bajo el título de enfermeros registrados. Solamente están disponibles para aquellos enfermeros o enfermeras que tienen títulos avanzados, que ya tengan títulos o certificaciones o una experiencia que los clasifique para un trabajo más avanzado.
And H-1Bs are granted in 3-year increments with a maximum of 6 years.
Y estas visas se dan en 3 incrementos, con un tiempo máximo de duración de 6 años, ¿ok? No se pueden obtener después de haberlos aplicado por tercera vez.
That is sort of a brief overview of the various different options, and I am happy to answer some questions.
Esto fue una pequeña... Nosotros, como hemos tenido charlas más en detalle del proceso completo en otras charlas anteriores que las pueden encontrar en nuestros videos de YouTube, yo le pedí a Kevin que solamente hiciera un resumen pequeño de esto, y lo que vamos a hacer es contestar preguntas. So we asked Kevin just to make a very short summary of the process, because we have had this explained in the past. So we wanted to really take advantage and just answer a lot of questions. So Kevin, let's start with 3 people already asked the questions. They were here in the United States under a legal status. There are 2 categories of these questions. One says people that voluntarily left the United States, okay, having been here illegally for a while, and one particular case that they are saying that they were actually deported out of the country. Can they apply for the program? Allow me to translate. Vamos a empezar con una pregunta que ya me la han mandado varias veces. Hay 2 categorías de la misma pregunta. La primera es gente que estuvo en los Estados Unidos bajo un estatus ilegal y salieron voluntariamente de este país. La pregunta es si ellos pueden aplicar a través de nuestro programa para obtener una residencia permanente. Hay una segunda clase de esa pregunta, que es aquellos que no salieron voluntariamente, fueron expulsados del país, que si ellos también pueden aplicar. So those are the 2 instances, Kevin.
Okay, I'll start with the first instance where someone was in the United States at one point illegally and they left, but they weren't actually deported.
Yeah.
They can apply for the program. They will have to disclose that they were present in the United States illegally. And as long as they have been outside the United States for a specific duration of time, they would be eligible to apply for the program.
And can you state the duration of time, or it is case specific?
It's going to be case specific because it depends on how long they were here. So if they were here for less than 180 days, then they're okay. If it was between 180 to a year, then they are subject to a 3-year bar. If it was over a year, then it's usually a 5-year bar. So it may be they may need to count days as to how long they were here. So it will be case specific, but it doesn't necessarily preclude them from applying.
And just the maximum, so I add that to the answer, and the maximum is for an amnesty of how long?
So the maximum is usually if they were here for more than a year, they could be barred for 10 years. So if they've been gone for 10 years, then they would be okay.
Okay. La respuesta para el primer grupo es la siguiente. Si usted estuvo aquí en los Estados Unidos, obviamente hay que decirle abiertamente a la migración que tú estuviste ilegal en los Estados Unidos, ¿ok? Y en principio no tienes problema en aplicar para poder obtener una residencia a través de nuestro programa. De cuánto tiempo tienes que haber estado por fuera del país por amnistía para poder reaplicar, depende un poco de cuánto tiempo estuviste ilegal en los Estados Unidos. Hay aquellos que estuvieron menos de 180 días, tienen un término relativamente corto. Personas que estuvieron más de un año, porque ahí en adelante toca empezar a contar días, pueden tener un castigo superior a alcanzar hasta el castigo más alto, que son aproximadamente unos 10 años, como amnistía para poder reaplicar para esas visas. Okay, Kevin, what about the second case?
So for the second case where someone was actually deported, the answer is similar. It doesn't always bar someone from participation in the program or getting an immigrant visa. But the deportation comes with a specific time that you need to be outside the United States. So you may have been barred for 5 years or 10 years or 20 years, depending on how many times this is happening and how many immigration violations you have. And so as long as you have served your deportation bar, you would be eligible to apply.
Okay. Aquellos que no salieron voluntariamente de los Estados Unidos también tienen derecho a poder aplicar para una visa, pero en este momento están sujetos al tiempo que el proceso de deportación les impuso, dependiendo de cuáles fueron las circunstancias. Pueden haberle impuesto un tiempo de deportación de 5 años o 10 años o 20 años, dependiendo del tiempo. Desde que usted haya cumplido el tiempo de la deportación, puedes aplicar al programa. So, there is a kind of a related questions to this, Kevin, that has to do with children that were brought illegally to the United States and left. Are they subject to the same condition? Somebody who was brought by their parents as a youngster, and even, I don't know, the 2 cases where somebody left underage or being an adult, are they subject to the same requirements? So una pregunta similar es, aquellos menores de edad que fueron traídos al país de manera ilegal por sus familias, si ellos también están sujetos a las mismas condiciones.
So usually the answer to that is yes. They would be subject to the same conditions as the adult. There may be some exceptions. So some of you may have heard about like DACA, where someone was a young child that was brought to the United States during a certain period of time, qualifying for a deferred action. And then sometimes they, depending on the reason why someone is getting deported, they may not impose that deportation on a minor child. And that if the minor child would also get a deportation order if they were deported. So they would have documentation.
And if they left voluntarily, is the child also subject to the same rules?
Yes.
Yeah. So, aún si te trajeron de manera ilegal o te deportaron habiendo sido menor de edad, estás sujeto a los mismos mecanismos dependiendo de la situación. Toca ver. A veces cuando las personas han sido deportadas por ser menores de edad, a veces la condición de deportación no la aplican igual para los menores de edad, pero en principio las reglas son las mismas. Okay. What about people who develop criminal record during their stay, or that was the reason for being deported? Will that change the rules, or is all in the same deportation? They were deported for a reason other than an immigration issue?
So that can change the rules. So if you committed a aggravated felony, for example, that may make you permanently inadmissible to the United States. And so it would be, that would be maybe a case where we'd want to set up a consultation to look at what the charge was that was filed, and then what the actual charge that you pled guilty to or that you were convicted of, and whether or not that meets the bar, one of the crimes of moral turpitude, and whether or not that permanently barred someone from the United States.
La extensión a esto es si hubo un récord criminal. Es importantísimo establecer una consulta de antemano porque hay que ver las circunstancias, porque dependiendo del tipo de crimen, muchos de ellos permanentemente te eliminan para poder inmigrar a los Estados Unidos. Algunos dependiendo de a la pena que hayas o al cargo que hayas confesado, puede ser que sí te permita o no, pero requiere un detalle, una conversación con el abogado en detalle para saber si puedes clasificar o no. Okay, so the other issue that is kind of related, and I'm trying to grab the question because they are just coming furiously. So I apologize, they are just coming so quickly. It's hard to read them all. But people about talking that they work illegally, they were not caught, but they were illegally, but they were using an illegal social security number. Will that put them in a special category or something like that? Personas que nos preguntan si ellos salieron voluntariamente, pero estuvieron trabajando durante ese tiempo con número de seguridad social que compraron de manera ilegal, que si eso también los descalifica o por algún motivo cambia las reglas para ellos.
So that can put you in a special category. So when I talked earlier about the ability to adjust status as an option, if you work over 180 days without authorization, that bars you from the ability to adjust status. And it is something that has to be disclosed. So they will ask you about it. So that can change your option. It may mean that you have to counsel process, but it wouldn't necessarily be a bar for you.
But they have to disclose that they
do have to disclose it, and it would be up to the officer
to say that's nothing major, and they ignore it, or they may decide that that was an offense big enough that they have to be an amnesty for some time.
Right.
But at the time, so I explained this clear to them, at the time of application, could you still place the application and then we're just subject during the consular process to potentially being denied the visa?
That is correct. So, which is really the case for anyone at any point. You go through the process, you get the I-140, and then ultimately you have a consulate interview, and the consulate officer has the ultimate discretion as to whether or not they are going to approve or deny you for the actual green card. But yeah, so we could apply for the I-140 for someone, even if they've worked without authorization in the United States, to get that approved, and it would ultimately be up to the officer at the consulate to determine whether or not they're going to admit them.
Kevin, in general, so before I give the full answer, in general, this is something that we will routinely do anyway, because the odds are that they will get their visa, or this is something that we will routinely not do because they will not get it approved?
So I think it's something that I would say you would routinely do. I think the circumstances might differ depending on how long and how often. If you did this for 10 years at a number of different organizations and you didn't have status while you were doing it because you were working illegally and you entered illegally, that would probably be a situation where we wouldn't do it. But if you were on a visa that did not authorize work, but you were otherwise lawfully present in the United States and you did it for a year, then I think that is a situation which is an officer would forgive.
Will forgive, okay. Esto es importante, escuchen bien. Aquellas personas que han entrado a los Estados Unidos de manera legal o ilegal. Aquellos que obviamente entraron de manera ilegal y compraron un número de seguro social, y lo más probable es que trabajaron bajo ese número, ustedes están obligados, y el abogado está obligado a decirle a Migración que usted trabajó de manera ilegal en los Estados Unidos. Esto no preclude el hecho de que se puede aplicar para la visa, pero la última, y puede ser en principio, la visa puede ser aprobada, pero la decisión final reside exclusivamente con el cónsul que va a hacer la revisión del caso. En muchos casos las situaciones fueron relativamente menores, sin muchas agravaciones. Los cónsules tienden a aprobar las visas sin ningún problema, pero recuerden que ustedes están a la discreción del cónsul que acepta el caso. En algunos casos, cuando las personas pasaron por varios empleos o varias organizaciones o por un tiempo muy extendido, es posible que el cónsul no quiera aprobar la visa. ¿Ok? Entonces, no es inmediato que la visa va a ser aprobada porque la aprobación de la visa tiene dos partes. Una es la aprobación aquí en los Estados Unidos, que el departamento la puede aprobar, pero la palabra final en todos los casos lo tiene el cónsul de lo correspondiente a tu situación. Entonces es importante discutir estas situaciones de antemano con el abogado para que se pueda tomar una decisión de cómo es la mejor forma de proceder bajo este motivo. Okay. I believe I did a good job, no, explaining what you explained. So hopefully Raul did too in Portuguese. An extension to that is someone is writing to me. This is the second person writing to me saying, there she has never been in the United States. She's never been illegal. She has two children. She's planning to come with them, but their father is in the United States illegally. Will that affect their immigration in any way, shape, or form? Allow me to translate. Una persona, como extensión de esta pregunta, nos dice que ella obviamente está en el proceso, quiere migrar a los Estados Unidos, quiere unirse con sus dos hijos, pero que el padre de los hijos se encuentra en los Estados Unidos de manera ilegal, que si esto afecta de alguna forma el proceso de ella o de ellos.
So it would not affect the applicant or her children in applying through the employment-based immigration process at all. That father is in the United States illegally.
So, para la enfermera y a sus hijos, el hecho de que el papá de los hijos esté de manera ilegal en los Estados Unidos no afecta su proceso para absolutamente nada. So she's quickly sending me a note. If can she include her illegal husband into the immigration process, or he's completely out of the process?
He is likely out of the process, but again, how long has it would be depend on how long has he been there, whether or not he has accrued too much unlawful status himself. So if he's been there for and then that more than 180 days, 180 to 360 more, and whether or not he's subjected himself to immigration violations, that will impact his ability to be ultimately included.
Good. So, and not even as she becomes a citizen, she will not be able to clear that issue.
Well, citizenship would be helpful, but she won't be able to do that for 5 years. And if she becomes a U.S. citizen, then in order to adjust his status, the U.S. citizen forgives a lot of the immigration violations, but in order to get his green card and adjust status and stay in the United States, he must have had a lawful entry. And so if he didn't actually enter lawfully, she didn't say whether or not he did or he didn't, but if he didn't enter lawfully, he would have to leave the United States and consulate process. And there would be a chance that he wouldn't get back in unless he got a waiver ahead of time.
La situación para aquellos, hasta que uno no se convierte en ciudadano americano, porque eso cambia muchas prerrogativas que la persona puede obtener después de la residencia. Bajo el proceso de residente es casi imposible, aunque obviamente depende de cuánto tiempo y cómo entró la persona de manera ilegal a los Estados Unidos. Las cosas pueden cambiar un poco, pero siendo residente, recuérdese que siendo ciudadano, perdón, y recuérdese que para volver ciudadano hay que esperar hay que estar viviendo en los Estados Unidos por lo menos 5 años para poder convertirse en ciudadano americano. En ese momento hay posibilidades de que el cónyuge cambie su estatus dependiendo si entró de manera legal y se quedó en los Estados Unidos versus que se entró de manera ilegal y no se quedó. Obviamente hay muchas preguntas por hacer y obviamente hay posibilidades y hay algunas posibilidades que pueden eliminar eso. The question here is, so what the next question is related to children. So which children, who is allowed to come with the nurse? La siguiente pregunta es, ¿quién puede venir con el enfermero o la enfermera como parte del proceso?
So spouses, children who are under the age of 21 and unmarried, those are all going to be your immediately eligible to come with you dependents generally. There is a process for, once you have your green card for getting additional family members. So those who may be over or 21 or older, but married, for example. Those who may be over 21 and unmarried, you can, at points bring those individuals over. Maybe it's a parent once you become a U.S. citizen. Those are options. So immediately you're going to be looking at those children who are unmarried, under 21, and your spouse.
So, para que nuevamente a todo el mundo le quede claro, en el proceso de empleado inicialmente solamente puede venir el núcleo familiar. El núcleo familiar consiste en el cónyuge casado, ¿ok? Tienen que estar casados, no importa el sexo del cónyuge, no funcionan uniones libres y los hijos menores de 21 años también desde que no estén casados, tienen que estar solteros por si acaso alguien tiene un hijo menor de 21 años que esté casado. Hijos mayores de 21 años que están solteros los pueden traer bajo el proceso familiar una vez que llegan como residentes. El resto de la familia en realidad únicamente a través del proceso familiar cuando se vuelven ciudadanos americanos, después de los 5 años de ser ciudadanos americanos. Okay? So the next group of questions of people who said there is a mix of questions related to this. People that got their tourist visa canceled for many reasons. Some people say that they went to the border, there were some questions, they deny entry either because they were here recent and it appeared that they were working even though they left originally. People who said that a child not stay here over, they were applying for a TN visa, but they didn't approve that. In any case, they removed their visas, but they officially did not receive a letter of being under any kind of penalty or anything like that. They didn't. Does that mean that they are free and clear to apply again, or should they be worried about something?
So unless you got some sort of a deportation order, or sometimes they will take your visa and they'll write a statute on it, like a number, a code section that would say that you're barred for a certain period of time. And then even then they would give you some sort of paperwork that says that you're barred. If they didn't do that, you are generally clear to apply. If they've canceled your visitor visa for some reason, you are still eligible to apply, and you would even still be eligible to apply for another visitor visa if you really wanted to. They can deny your visa or cancel a temporary visa, and that doesn't mean that you are ineligible to apply for permanent residence.
Okay. Aquellas personas que les negaron entrada con una visa de visitante a los Estados Unidos, o que les cancelaron la visa por algún motivo, pero no les dieron ninguna documentación diciéndoles que estaban prohibidos de aplicar o algo, o un tiempo por el cual les negaron, no tiene ningún problema. Aún si te cancelaron una visa de visitante, no significa que no puedas aplicar a otra visa de visitante o a una visa de residencia permanente. Es importante saber si hubo esas cancelaciones exactamente por qué se las cancelaron. El hecho de que usted no esté muy seguro no significa que en el sistema de documentación en Estados Unidos no se sepa por qué te cancelaron la visa. Es importante que ustedes nos dejen saber al abogado desde el puro comienzo, porque hay que revisar los casos para saber bajo qué situación estás de manera legal en los Estados Unidos. Next question, I'm trying to kind of bring some of the more interesting questions. Somebody was received a sentence in their own country. They've been convicted of something. They have a conviction. They are not disclosing, although I think one of them that I have heard in the past, the person who's asking me the question is not disclosing the reason for the conviction. But in the past, I know of a case of a person who was convicted for drugs. The fact that you have a conviction immediately means you cannot apply for a residency in the United States. Allow me to translate. Nos preguntan si una persona ha sido convicto en su país por alguna cuestión, que si eso significa que no puede aplicar a una residencia en los Estados Unidos. La persona me está haciendo la pregunta, no me dice los motivos, pero en el pasado me han preguntado en particular a aquellas personas que han tenido una convicción por drogas.
So that is going to depend on what the particular conviction is. So caught like a drug possession, like a minor drug possession charge, is you could likely get a waiver if you've kept yourself. It's the only thing that you've gotten in trouble for. You've kept yourself clean. You have letters of recommendation and support from people to prove that this is not a pattern or of behavior. If you have a drug trafficking type of charge or a specific amount, then it, depending on the substance, if it's a Schedule 1 U.S. substance, so cocaine, probably opioids, heroin, hard Schedule 1 drugs, that is likely going to mean that you're barred from the United States from applying for permanent residence.
So, la respuesta es depende un poco de la convicción. Si la convicción fue por algo menor y usted no tiene ningún otro motivo por el cual te ha sido castigado y se puede mostrar de que usted no ha repetido esas ofensas, que hay gente que pueda dar referencias a nombre tuyo, hay una alta posibilidad de que no hay ningún problema, no hay garantías, pero en principio no habría ningún problema. Aquellos que en particular tienen convicciones con respecto a drogas, sobre todo drogas que se consideran fuertes, potentes, las mencionaba, cocaína, morfina, fentanol, esas drogas fuertes, casi imposible conseguir una... other things not drug related, no, armed robbery, stealing a car, are those, depends also on how the penal code in the United States consider those offenses.
Yes, that's exactly right. So it'll depend on the crime and how serious the United States considers that crime. Those that are crimes that they consider crimes against moral turpitude. So those are going to be the things that we would think of as violent crimes generally. A theft is probably not going to have you barred from the United States, but an armed robbery certainly would. And so, we would work with you to figure out what it is that you were actually charged with and how what's comparable in the United States in terms of crimes to see whether or not you would be inadmissible.
Okay. Depende un poco del tipo de crimen, también tengo en eso en cuenta. Recuerde que se juzga a través del sistema legal de los Estados Unidos. Crímenes que se consideran ofensivos en los Estados Unidos, crímenes como robo a mano armada, crímenes de ese estilo, obviamente lo descalifican. Haberse robado algo menor, obviamente se puede discutir y hay posibilidades de que algunos de esos se pueda conseguir forma de aliviar algunas de esas situaciones. ¿Ok? I think we covered the issue of if it's just one minor issue that they're asking me like twice already, came back just as a continuation, is this a case where the spouse and the children are illegal in the United States. Obviously, the other spouse is not. They are want to apply. They want to know if the children are subject to the same rules as the adult. I mean, they were brought illegally to the United States. They are underage. Can they be put into the process with the mother? We understand the adult, but can the children be put into the process, or are they under the same conditions?
They're generally going to be under the same conditions as the adult that's in the United States illegally. They're not here in invalid status, so they're not able to adjust status, and they're accruing their own unlawful presence, even though they were brought here by someone else.
En el caso de los hijos, a pesar de ser menores de edad, están bajo las mismas reglas. Si entraron aquí ilegalmente y se quedaron versus si entraron ilegalmente a los Estados Unidos y cuánto tiempo llevan. Esas son las cuestiones que modifican las reglas del juego para cada uno. Please state loudly for everybody that having because it happens often, people does not get an approval of a tourist visa that does have no bearings on this type of resident. I think people get very concerned that they were denied once their tourist visa to the United States, and somehow that carries some weight for this immigration process. Allow me to translate. Para aquellas personas que han aplicado para una visa de turismo y han sido negadas, le estoy pidiendo a Kevin que les dé una respuesta para que estén tranquilos, ¿ok?
Yeah, so you're absolutely right. The tourist denial has no bearing on your immigrant visa denial. So tourist visas can be denied for several reasons. The most common reason is that the officer does not believe that you intend to come back and that you're going to overstay your visa. And so you don't get that same sort of problem when you go through the green card process, because you are telling them that you don't intend to come back to your home country. You intend to come to the United States permanently.
Okay. Entonces, el hecho de que a usted le hayan negado una visa de turismo en el pasado no afecta para absolutamente nada su proceso. Eso no tiene ninguna relevancia. Inclusive una persona puede volver a solicitar una visa de turismo en los Estados Unidos. Ir a solicitar una visa de turismo con la intención de venirse a los Estados Unidos a quedarse aquí de manera permanente y haber obtenido una negación, obviamente cambia un poco las reglas del juego, y es importante que ustedes discutan eso con el abogado. ¿Ok? Y ha ido de forma legal a Estados Unidos, pero tuvo un hijo estando. Okay, so this is another question that comes often. I came legally to the United States. I was here legal, but I had a child while here. Okay, as a tourist. Okay, and she never extended her stay. She her daughter obviously has a U.S. citizenship. Is there any trouble because she came here to have an American baby. In other words, ya, allow me to translate. Alguien nos pregunta, una persona que vino, esto legal, dio a luz aquí en los Estados Unidos, tiene inclusive una hija que tiene nacionalidad americana, que si haber hecho eso tiene alguna implicación para ellos.
So the answer to that, the act of coming to have a United States baby is not in and of itself. They admitted you in the visitor class, and so that doesn't make you inadmissible to the United States at all. The one thing that I would want to check in that particular case is whether or not she overstayed and how long. Did she go back?
Well, she said here that she did not overstay.
Okay, did not overstay.
Did not overstay.
Okay, so no, that does not.
No. I think they worry because of who may have paid for that, where they got Medicaid or something like that to help pay for the delivery in the United States. Will that affect their stay? She's not saying that, but I've seen this type of questions in the past. Would that has any bearing?
It should not have any bearing. No, not on the employment process.
Not on the employment process. So, si tú viniste a los Estados Unidos, tuviste aquí tu bebé, te saliste de manera legal, no tengo ningún problema, no hay ningún problema aún si solicitaste ayuda económica del Servicio de Salud de los Estados Unidos, eso no tiene por qué tener ninguna implicación por el proceso de empleador, ¿ok? Okay, so the obvious question, and this is coming fast and furious from a lot of people, is timings. Could you elaborate a little bit on the timings? Okay, so I accepted the offer from the hospital. Give us let's say you have basically all the paperwork on your hands. So give them a sense of timing. Allow me to translate. Personas que la pregunta de cuánto se demora el proceso migratorio en los Estados Unidos, si estoy por fuera de los Estados Unidos, cuál es la demora del proceso. Entonces le estoy pidiendo a Kevin que nos dé unos estimativos de cuánto se demora el proceso.
So the timing is influenced by a couple of factors. Whether or not someone has a prevailing wage already. And should we assume that they do?
Yeah, let's assume that they do. Mm-hmm.
Okay. So assuming that someone has a prevailing wage already, then we would probably say that the timing is, well, it's 15 days for the I-140, and then the time it takes to get to the consulate interview. And that usually is going to depend on what consulate you're going to. But I would say if you're talking about 6 months or less, and then the question is whether or not your priority date is current and what country you're from.
Okay, so let's put a bit more detailed numbers to that, Kevin. So once you have all the paperwork in your hand, let's say within less than a month, you will get the visa approved from USCIS.
Yes.
Okay. And the next question is, I think, the trickier one, which is you're doing the DS-260 process, you're filing with NBC. So some general estimates that obviously we are filing today. We're not filing whatever the visa bulletin says, we're filing today. So you anticipate that the person could be going to a consular interview in a year, in 6 months, in a year and a half, somewhere in between.
I would say in a year would be what I would estimate, because right now the visa bulletin is not current. Mm-hmm. And so we're talking, and I would have you filed and approved for an I-140 in a month. You could complete your DS-160 or DS-260, fill and send your documents into the consulate within the next month. I recently filed a number of maybe some of the individuals on this call, and I've already heard back from the NVC saying, okay, now you can pay the fees and start to complete the DS 260. So that's happening really quickly right now. The bigger weight is that the visa bulletin is not current, and so it's right now
about 8 months behind.
About 8 months behind. So I would say with those 2 months plus the 8 months of time, you're probably looking at closer to a year unless something changes with the visa bulletin between now and then.
Okay. Esto es importante, escúchenme todos, mi amigo Sergio. Lo más importante es la fecha que determina todo, es el momento que los papeles entran al proceso I-140. Con todos los papeles en la mano del abogado, estima que en 2 semanas tienes la visa aprobada en los Estados Unidos. En este momento, el NVC, que es el que hace el proceso de visas para poder entrar al proceso consular, él dice que está manejando relativamente rápido, más o menos en un mes. Ya esos documentos van a estar listos de camino al consulado. En ese momento, la pregunta es, ¿qué tan rápido el consulado procesa eso? El consulado ya los tiene, ¿qué tan rápido los va a procesar? Y eso depende de qué tan al día está el boletín de visas, ¿ok? En este momento el boletín de visas está procesando febrero del 23, ¿ok? Significa que estamos aproximadamente unos 8 o 9 meses atrás, ¿ok? Entonces estima, di tú, una persona que sus documentos ya están acabados y están en el estima, puede ser tan rápido como 9 meses, puede ser más o menos un año. ¿Ok? Obviamente depende en qué tan actualizado esté el boletín de visas. En este momento está aproximadamente unos 8 o 9 meses atrás. ¿Ok? Very good. So, Kevin, there are so many questions. I'm having a hard time reading all of them. They are coming so fast. It's like we can be here for like 7 hours, trust me. I think many of them we kind of already asked. There are many people that they got denied their tourist visa. They get concerned that means a denial. We already answered that question. There is people who, even though we answered this question, if their husband is illegally here in the United States, it's not an automatic entrance into the process. Depends of whether that person came legally or did not come legally into the United States and for how long they've been here. So, aquellas personas que siguen preguntando que tienen un esposo o una esposa que está en los Estados Unidos de manera ilegal, no es una automática. El esposo, no la persona, el esposo no tiene una automática entrada, mientras que tú solamente seas residentes al programa. Depende hace cuánto que están acá y por cuánto tiempo han estado legal en los Estados Unidos, ¿ok? Tiene visa, ya ha ido de forma legal a los Estados Unidos, pero tiene visa, already answered that. Can you bring any other family members besides the children? Okay, or when can I bring my parents is really the question that is coming across. So la pregunta que dice es, me quiero llevar a mi papá y a mi mamá, pueden venirse conmigo. So the question is, can I bring my parents?
So your parents are not immediately allowed to follow you to the United States. Once you become a U.S. citizen, you can then apply for a green card for your parents. You have to be a permanent resident for 5 years in the United States before you're eligible to apply for citizenship. And then after you become a U.S. citizen and you take the oath of a United States citizen, you are eligible to apply for your parents. And like the employment-based visa bulletin, there's a family-based visa bulletin. And so depending on what country your parents are from, that may impact the timeline for when they're going to be able to come. But generally, you got to wait 5 years to become a citizen, and then at that point, you're allowed to file for your parents.
Okay. Any idea how long is taking on some countries, on the majority of the countries? Another 5 years after that, another. I see you quickly looking into the bulletin.
Yeah, I'm looking at the bulletin really quick here to try to give you more of a accurate
answer. I'll translate.
answer.
Aquellos interesados en traer a los padres a los Estados Unidos, tienes que esperar los 5 años para volverte ciudadano americano. Una vez que te hayas vuelto ciudadano americano, puedes en ese momento hacer la solicitud para traer a los padres. ¿Cuánto tiempo se demora desde ese momento en traer a los padres? También depende de lo que diga el boletín de visas para la familia. Obviamente, como ciudadano americano, entras en una prioridad diferente y tus padres también entran en una prioridad diferente en ese momento. Mientras que estamos contestando, Kevin está revisando en este momento en que está el boletín de visas de familia para darte una idea un poquito más específica.
So I misspoke too. So parents are going to be of U.S. citizens are going to be immediately available, so they don't have to worry about the bulletin. But they will have a processing time, likely, at least if we're looking at right now, of about 14 months.
Ok. Los padres de ciudadanos americanos no tienen que esperar al boletín de visas, pueden aplicar inmediatamente, significa que entran en prioridad alta. Hijos y padres entran en prioridad alta y estima que en este momento por ahí 1 año y medio para que les salga la visa después de que te hayas vuelto ciudadanos americanos. Okay. Medical reasons why you will be denied a visa. Okay. Is there, are people with an HIV, will they be denied a visa? People with a chronic disease like, well, there were a couple of them mentioned here, people who are diabetic, they have a diabetes. There is a person who seemed to have had an accident, kind of walk with a limp. Is that a restriction? Are there any of those are restrictions to be able to apply for a visa in the United States? And allow me to translate, I'm sorry, Kevin. Personas que están preguntando si hay alguna razón médica por las cuales no puedan entrar en los Estados Unidos. Algunas personas me dicen que obviamente tienen algunas enfermedades inmunológicas o tienen algún problema motriz, que si estos son algunas restricciones para poder no ser elegidos en los Estados Unidos.
So HIV, like you said, diabetes, those are not going to be communicable diseases that would make someone ineligible to come to the United States. The current diseases that are generally going to be considered communicable diseases that would either make someone ineligible or have to undergo testing. Additional testing is going to be like gonorrhea, syphilis at an infectious stage, active tuberculosis, and then I think there's Hansen's disease. I think that's leprosy. Those are going to be the communicable diseases. Was there a second part too?
Yeah, if somebody has a motor deficit, that have a problem walking or something like that, I mean, walk with will that cause any?
No, that would not cause them to be ineligible for a green card. It's really aimed at those sort of communicable diseases that can be transmitted to other people in the United States that they're concerned with. And there's a list of the diseases, and it often, HIV used to be on the list. They took it off the list in 2010. So it does change. But right now, that is not going to be one of the diseases that keeps you out of the United States.
Solamente la gran mayoría de las enfermedades crónicas en general no descalifican a la persona. Enfermedades motrices no descalifican de ninguna manera a la persona. Algunas personas que tienen enfermedades infecciosas activas, obviamente van a ser requeridas que hagan un examen y depende de si están controladas o si han sido limpiadas, no necesariamente o inmediatamente eliminadas. So once a person is no longer infectious of that particular disease, they are still eligible to apply for the visa, correct? Like syphilis case, and they are no longer infectious, they are some of those. So just want to make sure I'm telling them the right thing. So as far as de la enfermedad contagiosa está controlada, no hay ningún problema. I wanted to move to a different type of questions, but there is a particular item that it keeps popping up in 3 or 4 questions. I think there's a bit of a misunderstanding. People freely throw the word retrogression, visa retrogression, like it's like, could you explain to people what really is visa retrogression and how can they or does not affect their case?
Sure.
Varias personas escriben sobre lo que se llama la visa retrogression, ¿ok? Yo creo que algunos no tienen un buen entendimiento de eso qué significa, entonces le estoy pidiendo a Kevin que les dé una mejor explicación, ¿ok? So in particular, the case, I'm current, or I did my filing, is, let's say my filing was done in January of this year. The current bulletin visa said that as of February, everybody is current. If all my paperwork will retrogression affect a case like mine?
So visa, I guess, retrogression affects depends on your priority date. So the way that it works is that, you get that priority date when you file your I-140 petition. And then you check the bulletin to see whether or not you're current. You can file the consulate process or the adjustment of status when you are current. If at some point the bulletin retrogresses, they will hold your adjustment of status filing, or if you've already gotten through the consulate interview process and there's not a green card available, they will keep your place in line, and then as soon as you're current again, they'll issue you the visa. Or if you're in the consulate process and you're waiting for an interview and you're not current, they'll hold your place in line. And then when it becomes current, you become current again, then they will then schedule you for an interview. So it can impact you in that you may not physically get the green card, but it will not impact your case that in a way that it won't negatively impact your case. It just may add additional time.
El proceso de retrogresión, obviamente lo más importante es tener la posición en la fila. Si por algún motivo hace una retrogresión en los casos, si ya pasaste, por ejemplo, el proceso de entrevista y está todo aprobado a nivel consular, puede ser que se demore un tiempo adicional en entregarte la visa porque están esperando que se vuelva corriente. O alternativamente, si ya estabas en fila, ya tenías para la embajada, ellos mantienen tu lugar en la fila, esperando que se reabran las visas. I think there is a bit of a misunderstanding because, the bulletins got changed capriciously up, forward or backwards. In September, you get this big full of visas, and so the bulletin visa jumps almost and becomes everybody current, and suddenly a month later or two, suddenly we're back 3 or 4 months behind. So I don't think people understand exactly, or a few months before the end of the year, suddenly the visas jump back ahead. So people get a little bit concerned that things only move in one direction, but things can move in both directions.
Yeah,
so,
they move in both directions, and it's because at the beginning of the fiscal year, they get more green cards available. And so throughout the year, depending on demand, it can go forward or backwards.
Es importante a los que no entienden bien el proceso de retrogresión que el boletín de visas se mueve en las dos direcciones. Por ejemplo, alrededor de septiembre, octubre, cuando llegan las nuevas visas, el boletín se mueve para adelante. A medida que el año progresa, empieza a retrogresar un poco. A veces, incluso hacia el final del año, en cualquier momento, el boletín se puede mover en una dirección de las otras. El boletín no es estático, él se mueve en ambas direcciones. Y aún así, a veces en las embajadas sí tienen, por algún motivo, ciertas visas y las van a otorgar. We've been in cases that the bulletin may have said something, but the embassy still were giving the visas. They seem to already had those visas allocated to them, and they were still producing visas. So the bulletin did not affect the people with those visas.
Yeah, that happens. So every month there are two different charts. One is a final action date chart, and one is a dates for filing chart. And every month they tell us which chart to look at. And so sometimes they may use the dates for filing chart, which would mean you can still go ahead and file even though maybe a visa isn't necessarily available, but it will be available. And so it doesn't stop the process. And then some months they tell us that you need to use the final action date chart. And that is meaning, hey, unless a visa is available to you, we're not going to have you actually even apply. And so that when the visa bulletin itself comes out, they tell us additionally, usually within a couple of days, which chart we're supposed to look at.
Okay. But that changes month to month.
Yeah, sometimes it stays consistent, 2-3 months in a row, but yes, it can change every single month.
Correct. El Departamento de Inmigración le dice a los abogados si les permiten hacer acción en ese momento para mandar la solicitud a las embajadas, o si a veces se tienen que quedar tranquilos unos meses antes de enviar, dependiendo de la situación, pero eso varía de mes a mes, de boletín a boletín, y cuáles son las acciones, así que no le tengan mucho misterio a eso, porque eso varía constantemente, ¿ok? Okay, I'm trying to read through. Just going to give you a couple of more questions, and I think we answer. Otherwise, trust me, Kevin will be here in a permanent in a position, a clinical coordinator, apply for a permanent resident for the beginning or only option. There are some questions I'm not 100% understanding, so I'm not necessarily going to try to answer those. Okay, so there is a very I think there is one thing that you need to really clarify to people. There is some people that are anxious to arrive in the United States, and they want to come here under their tourist visa and just stay here and do everything from here. Okay, I think there are several motivations. One, they want to leave their country for whatever reason as quickly as possible. But the second issue is some people feel that this is a better way to learn maybe the language just staying here than staying at home. Money set aside where you have money to pay for a student visa. Could you tell them what to do or not to do if you are only going to arrive here on their tourist visa? This question has come maybe 7 times tonight. Okay.
Sure.
Allow me to translate.
Okay.
Escuchen bien, por favor, porque le estoy pasando a Kevin una pregunta que nos hacen con mucha frecuencia. Personas que están ansiosas, tienen una visa de turismo y quieren venirse desde ya a los Estados Unidos como turistas y hacer el resto del proceso desde acá, habiendo entrado como turistas. Escuchen bien en qué consiste eso. Ok, Kevin.
So when you enter on a tourist visa, you are attesting to the officer that you intend to return to your home country. Um, that doesn't mean that everybody that comes on a tourist visa actually goes back to their home country, but that is what you are saying to the immigration officer. Um, Obviously, sometimes things change. I think someone said they had a child. Pandemic might strike, so there are times when things change, and so assuming that you, in good faith, don't plan to lie to the immigration officer, you could potentially file an I-140 and adjustment of status on a visitor visa. Um, you wouldn't be able to work likely for probably 8 months to 12 months. So you would file that adjustment of status and the I-140 together. If you could, if your priority date is current. If your priority date is not current, it's going to take even longer. So you would be waiting probably, instead of 8 to 12 months, you might be waiting more like 18 to 24 months before you would be able to work, if your priority date is not current. And so you would need to think about whether or not you're able to sustain yourself in the United States for that period of time without working, because working illegally in the United States would cause immigration issues for you.
But that's also assuming that you can file an I-40 for them within maybe 4 or 5 months since their arrival in the United States. That most of them will not qualify for that. Most of them they don't have NCLEX pass, they don't have English pass, they don't have what it takes to apply for an I-140. They would like to do all the process here, which potentially that itself will take 1.5 to 2 years, even before they will even have the requirements to apply for an I-140.
Right. So if they didn't have their, CGFNS or NCLEX, or, hadn't passed foreign language, we wouldn't be able to get to the point of filing the I-140 until they had done all of that. And so that would add additional time. I mean, you would be talking about probably, like I said, 2.5, 3 years, maybe, based on the visa bulletin, before you were able to actually begin working.
But they will stay in the United States illegally because they will exceed their 6 months.
Yep. The only way that I think it would ever make sense for someone is if they were already had all of their documentation. They had passed all their tests and documentation. There was a prevailing wage and they had a job offer, and they were ready to go, and the visa bulletin was current for their country of birth. If all of those things lined up, and they were okay with not working for 8 to 12 months, then you could do it if you wanted to do it. But everything would have to be ready ahead of time.
Let me translate that, and then I'll ask you maybe one last question for tonight, and then what we'll do is we'll invite you in the future to answer, because the number of questions here are just piling up and it's hard to get through all of them. Sure. The related question is, assuming you have the funds, because the issue comes an issue of money too. As long as I arrive here as a student or in another legal situation like a J visa, an au pair or something like that, are there any restrictions to do the filing while I'm here in the United States? I come legally to learn English, to stay here have the funds to stay here for as long as I want to study English here. Will that preclude me from remaining a student and doing my application? And when can I swap, or vice versa? If I I arrived in the United States as an au pair, and I'm working on getting my requisites. Let's say I already got them. Are there any problems of moving from one job to the other?
There's no problem unless there is a restriction on the particular visa. So sometimes J's have a 2-year return home requirement. That may be in effect depending on, you know, who sponsored your J. Or F1s are usually, you wouldn't have any, you know, if they came on a student visa, they wouldn't have any sort of restrictions. B's, you aren't supposed to file for an adjustment of status for B's within 90 days of someone arriving. It's an unwritten rule that if someone applies within 90 days of arriving on a visitor visa, that they were untruthful when they arrived. And so you would want to put some time between the time that you arrived on a visitor visa. I mean, it isn't, you know, it isn't illegal, but you would likely get denied for your adjustment of status if you did it sooner than 90 days. So that's a long-winded way of saying it can be done in certain circumstances, but you may want to look at the particular type of visa and put some time between when you apply for your adjustment of status, at least 90 days. I would for visitor visas for sure.
Cuando uno entra a los Estados Unidos con una visa que no es obviamente una green card, una visa de turismo, una visa temporal, para poder entrar al proceso hay que hacer eventualmente un ajuste de visa. Diferentes visas tienen diferentes requerimientos y obviamente hay dos supuestos importantes. Supuesto número uno, que la persona, en la situación de que una persona ya ha hecho los requisitos, ya cumplió sus 3 requisitos, ya habla inglés y ya pasó la prueba de inglés, ya certificó su título en los Estados Unidos y ya tomó y pasó la prueba del NCLEX. Bajo esos requisitos, una persona que viene con una visa de turismo, en teoría, después de 90 días hay una regla en general que hay que esperar unos 3 a 4 meses para poder solicitar el cambio de ajuste. Podría hacer el cambio de ajuste estando aquí sin ningún problema, pero que tiene que de todas maneras estar preparada porque no puede trabajar de manera ilegal hasta que no le sale la visa y que va a tomar los mismos 9, 10 meses, un año en que les hagan la visa encima de los 4 meses de espera que tuvo que hacer. Entonces tienes que estar preparado para poder, en teoría, no estar trabajando ilegal para poderte quedar en los Estados Unidos. Las personas que vienen con una visa de estudiante, esas visas en general no tienen mucho problema porque las visas de estudiante desde que estés estudiando te mantienen un estatus legal y hacer el cambio de estado no crea mucho problema. Personas que tienen unas visas como au pair, las visas J, tienden a tener un determinado tiempo en el que hay que completar ciertas cosas. Había que ver que ya acabaste los requisitos o si los has estado haciendo mientras que estabas en ese proceso, cuánto tiempo te puedes estar, etcétera, etcétera. Se puede aplicar para el cambio de estatus, pero el tiempo que continúas en los Estados Unidos, estás en un proceso en el que en teoría no deberías o no estás trabajando ilegalmente porque eso puede afectar tu otra visa. Es importante que tengan eso en cuenta, ¿ok? And okay, I think we should think about that. There is one last question that somebody is begging me, which is the people with children with disabilities, which I think it comes with a little bit of frequency. I have a child that is fully dependent, and there are 2 instances. Obviously, one is an underage child, and the other one is an 23-year-old, is an after 21 years old of child. Well, can they come with me is the question. So, la última pregunta esta noche, yo sé que no vamos a poder contestar todas. Es la pregunta relacionada con tener un hijo con discapacidad, con incapacidad, si se puede traer como parte del proceso, menores y mayores de edad.
So the answer to sort of the first scenario where you have someone who is younger, under the age of 20, a minor child, they would be able to come with you. They would follow the same process as non-disabled children, and they could get a green card unless they had some sort of one of those communicable diseases that made them inadmissible. But if it's a disability, they could certainly come and get a green card with you under the same process as a child that is not disabled. For the second scenario, where someone has a adult child who is disabled, they would, is just a green card holder, would not be eligible to apply for the green card with them because they are over the age. So they don't make an exception for an adult child who has a disability. They don't distinguish between disabled and non-disabled. What I've had clients do in that instance is that they have gotten them visitor visas, and the Immigration Service has continued to allow them to renew their visitor visas, even though they're only good for 6 months. They've continued to let them renew them because of the situation, and the U.S. Immigration Service doesn't have a visa option for this type of situation yet, and so they give more latitude in visitor visas,
which they don't do on other circumstances, because oftentimes people say, well, I'll bring my child, which is not disabled. They have a visitor's visa until 28, which by then I may be already a citizen. But then they can just stay here as a visitors, and that's not the case. They will have the strict limitation of the 6 months, unless what I usually tell them is that you need to consider making them a student in the United States.
Yep. And usually visitor visas, they're fairly strict with them because the intent is for someone to return home. But when you are the sole caretaker or the primary caretaker for a disabled adult child, and there's no real other option, so there's two things. Sometimes people will do what they call humanitarian parole, and have their child paroled in on a humanitarian basis, or they will go with the visitor visa, and the officers are usually pretty good about just continuing to extend those visitor visas.
Okay, so allow me to explain that, and maybe that will finish for tonight. Las personas que tienen hijos con incapacidades o discapacidades, los que son menores de 21 años no tienen ninguna restricción, los puedes traer, lo mismo que traes a cualquier otro hijo dependiente tuyo. La migración de los Estados Unidos no hace distinción entre hijos que no tienen incapacidades y aquellos que tienen discapacidades. Si son mayores de 21 años, no puedes aplicar. Solamente puedes aplicar una vez que ya están acá. Lo que Kevin comentaba para estos que son mayores de 21 años es que con frecuencia se solicita una visa de turismo, y como no hay una categoría específica para este tipo de individuos, hay cierta latitud que la migración americana permite renovar la estadía. Recuerde que la estadía de turismo es máximo por 6 meses. Si tú vienes con una visa de 6 meses y no tienes una incapacidad, tú tienes que salir. No puedes estar más de 6 meses al año en los Estados Unidos. Tienes que salirte del país, no puedes estar más de 6 meses. Pero en estos casos dan prórrogas. Se puede solicitar una prórroga, y en general la migración americana tiende a dar esas prolongaciones hasta que eventualmente te vuelves ciudadano y puedes solicitar un cambio, un estatus diferente para esas personas. Por favor, tengan en cuenta que si tienes una persona que no tiene ninguna incapacidad, esto no aplica para ellos. En esas circunstancias, el último comentario que yo le hice a Kevin es que la mejor alternativa sería traer a esos hijos mayores de edad bajo algún tipo de visa de estudio que no tiene esas restricciones. Kevin, I can tell that you can do this seminar every every Wednesday, and the amount of you know, when it comes to immigration questions, they are endless. In any case, on behalf of all our group, no, Debbie, no, and all of us, we are so pleased to have you, no, as part of our team. No, we look for opportunities to have you back here in the future. In the future, thank you very much. And I'm sure I'll keep compiling some questions, and slowly for your next session in a few months from now, we'll have them already, you know, pre-assembled, and we'll start creating maybe more of a Q&A to the for you to be able to answer a few of these questions.
Yeah, absolutely. The one thing I wanted to just say, there was a lot of questions about minor children and being in the United States. If people have minor children who maybe have accrued some unlawful presence, I'd love to have a conversation with them, because if they're not subject to that 3 or 10 year bar, there's probably something that we can do. They're probably not accruing unlawful presence, and they would be okay. But it's a little bit nuanced, so it's sort of individualized.
Correct. Kevin les dice a aquellos que tengan cualquier situación que tuvieron con un hijo de manera no legal en los Estados Unidos, él les ruega, les pide que por favor se comuniquen con él, porque hay muchas cosas que se pueden hacer, pero dependen de la situación específica individual de cada persona, pero hay muchas alternativas. Aquellos que tienen importantes preguntas, Kevin es muy generoso con su tiempo, ¿ok? Aprovechen lo que él, las consultas con él son relativamente económicas, y es mucho mejor cuando uno puede discutir sin tener que discutir en público casos específicos de una persona, llegar a una conclusión que puede cambiarles la vida de manera permanente. So I was telling them to take an advantage of your generous fees and time to reach out to you for specific questions, because they could actually change their lives. Thank you, Kevin. So what I'm going to do, a couple of people is quickly asking me, how can you get in touch with you? How can they get in touch with you? Do you want them to go through us and we redirect them to you? So I'll be happy, because our numbers are out there. Or do you want me to publicize your information?
Yeah, it's up. I'm happy if you want to, share my email and my assistant's email. We'd be happy to set something up directly with them. I don't want to add more to your plate. I know you guys are already pretty busy, so I'm happy to do that.
Thank you.
Okay, so feel free then, if you want, on the chat, put the email that you want them to contact you directly. That will not be an issue. Kevin les va a dejar un correo para que ustedes, aquellos, porque unas 6 o 7 personas ya me mandaron solicitando que cómo pueden contactarlo a él directamente. Entonces, por favor, cópienlo aquí del chat. El correo que Kevin les va a dejar, lo pueden contactar a él directamente. No hay ninguna cuestión. La persona que me pregunta que si alguien tiene problemas económicos en el país, que si eso le restringe obtener una visa en Estados Unidos, absolutamente no. ¿Ok? Juan, while Kevin writes that, I'll give you a second to ask verbally. Juan.
Sí, ¿me escucha?
Sí.
Yo tengo una inquietud. Si, por ejemplo, ¿qué tiempo concerniente a los títulos que se debe de tener para aplicar al curso, o sea, a la oportunidad, el tiempo requerido? Por ejemplo, en mi caso, yo soy técnico superior en enfermería, avalado por la Universidad Pucamaima, pero ustedes requieren 3 años y yo duré 2 años y 6 meses. O sea, a mí solamente me estarían faltando 4 meses, pero que esos 4 meses mayormente aquí nunca se hace. Aquí siempre el técnico universitario, que es lo que ustedes exigen, que tenga 3 años, es en otros países que duran 3 años. Aquí siempre dura 2 años y 6 meses, que es lo mismo que los 3 años.
Juan, brevemente, pero te invito a una reunión informativa donde con gusto te explicamos eso en gran detalle. Esto no tiene que ver con inmigración en los Estados Unidos, tiene que ver con los consejos de enfermería en los Estados Unidos. Tiene que ver con que la carrera hecha en los 2 años y medio que tú hiciste, ¿ok? Tenga los créditos suficientes para clasificar como el título de enfermero profesional en Estados Unidos. En muchas instancias, porque le hemos hecho estas revisiones con frecuencia, pero podemos revisar en particular tu título, si tú quieres, con la compañía verificadora. Lo que pasa es que los títulos que no tienen ese número de créditos no terminan clasificándolos como títulos profesionales. Si no son profesionales, no podemos aplicar para la visa. ¿Ok? El hospital no te va a hacer una oferta porque en este momento no estamos aplicando para esa, pero aprovecha una reunión informativa, con mucho gusto charlamos, me puedes escribir en particular y te puedo mostrar cuáles son las rutas para revisar tu título individualmente. ¿Ok? Muy bien.
Thanks very much, Kevin.
Thank
You've got a real nice way of presenting the information. It's easy to understand. So thanks. Really appreciate it.
Happy to do so, and I'm happy to come back another time too. And thank you guys for inviting me.
Yeah, have a happy Thanksgiving.
Yeah, you as well.
Les estamos dejando en el chat los horarios de las reuniones informativas, tanto en español como en portugués. Aprovechan y las copian. And I have my fabulous Amanda here with us, who's going to tell us about our next meeting.
Yes. So next week, to get ready for Thanksgiving, we have BSR coming. So we're going to learn a little bit more with BSR next week, our English Academy. And then for the last week of November, we have Nash Institute presenting, talking about our coaching program that we have. So 2 great webinars to round out the month.
Okay, entonces, porque nos estamos acercando al Día de Gracias aquí en los Estados Unidos. La próxima semana tenemos a la academia que va a venir. I forgot the subject that they're going to talk.
They're going to talk about, the title is there a recipe for success when learning a new language or in life?
Okay, van a hablar si hay una receta ideal para aprender un lenguaje extranjero. Y después de eso tenemos al Instituto del NCLEX, se va a venir a charlar con ustedes directamente también sobre preguntas específicas sobre la cuestión del NCLEX. Estén pendientes de las invitaciones. Again, Kevin, thank you very much. En una oportunidad en el futuro, no con mucha demora, volveremos a traer a Kevin para que les conteste más preguntas migratorias a los Estados Unidos. Thank you, everyone. Great night. We'll see you guys soon. Gracias por venir y nos vemos en una de las próximas reuniones.
Thanks, Kevin. Thanks, Raul.
Very nice to meet you all. Good night.
You as well. Thanks.